I'm good to go. You good for me? Good evening, everybody. My name's Jason Sands. I'm just going to kick off this Committee of Adjustment meeting this evening on on July 24th, 2024. As you know, for those of you who have been to these meetings before, I'm not typically the one who starts the meeting. The chair to my right, Mr. Clancy, starts the meetings. However, I have preamble that I'd like to read so that everybody is cognizant in the way in which the meeting will run this evening, and the information in which will be heard this evening will be considered as part of the statutory public meeting. I will provide the preamble and then turn it over to our chair to initiate the rest or commence the meeting itself. So good evening and thank you for joining. I would like to ask that all devices be turned off or silenced. The meeting tonight is being held in a public meeting, and it's being held under the Planning Act, being live streamed to our YouTube page here at the Township of Stone Mills. Notice of collection of personal information collected as a result of this public meeting is collected under the authority of the Planning Act, and it'll be used to assist in making a decision on this matter. Persons speaking at this meeting are requested to give their full name and address for the recording in the minutes. All names, addresses, opinions, and comments may be collected and may form part of the minutes, which will be available to the public. Additionally, interested members of the public can email the clerk or the manager of development services if they wish to be notified regarding any particular application. Questions regarding this collection should be forwarded to the manager of development services, which is myself. Tonight's meeting is to consider public meeting reports. These reports do contain a staff recommendation, and the recommendation is typically to approve with conditions, defer the application, or to deny. After the planner's presentation, which is this evening, Emma Stuckey on behalf of Arcadis, sitting to the chairperson's right, the committee members will be able to ask questions of staff and or the consultant planner, followed by any questions from members of the public. Following the question and answer period, this committee then makes a recommendation of the applications to approve, defer, or deny. Following the committee's decision, notice will be circulated in accordance with the Planning Act. If a person or public body would otherwise have the ability to appeal the decision of the committee to the Ontario Land Tribunal, however, the person or public body does not make an oral submission at the public meeting or make a written submission to the Township of Stone Mills before any application is provisionally approved, deferred, or denied, the person, public, or public body is not entitled to appeal the decision. With that, I will turn it over to Mr. Clancy.
I'll call the meeting to order. I will welcome everyone here this evening. I see we have a decent turnout again. Anyone wishing to speak is more than welcome to speak to anything on the agenda. You will be given 7 minutes and 7 minutes only. You can only speak once. I'd ask for the approval of the agenda. Moved by Bob, seconded by Aaron. All those in favor? Carried. Any additions or deletions to the agenda? No. Declaration, conflict of interest, general nature thereof. Is there any?
Can I make a comment on this before I answer?
Pardon me?
Can I make a comment in regard to a conflict of interest?
Yes, go ahead.
For those of you who were before you, you know that I declared a conflict on those other severances that were approved. And the reason for that was that I was kind of involved in maybe developing some different alternative developments for that parcel of land with the applicant, Theo Nyberg. And that's the reason I declared a conflict at that time, because I was kind of involved in as a surveyor, to develop maybe something what I consider to be maybe more appropriate. So I declared a conflict. So in this case, with these lots, I don't have a conflict. So there's no conflict on this for me.
Anyone else? No. Let the record show then, there's no conflict of interest. Adoption of the minutes. Need a mover, and it's moved by Marilyn, seconded by Bob. Any errors, omissions, discussion arising out of those minutes? June the 25th? No? All those in favor? Carried. Severance application. B41-2023, Rennick. Would some of the Rennick family like to join us at the table, please? Emma, will you give us the preamble, please?
Yes, through you, Mr. Chair. If it's all right, I'll speak to applications B41, B42, B43, and B44 concurrently, as they all are from the same parcel of land. So these applications seek to create new lots on Rennick Road. The parcel A has a lot area of 56.2 hectares with approximately 1,053 meters of water frontage on Vardy Lake Road. It's vacant and intended to be used for conservation uses. That's the parcel to the south there on the screens. Severed parcel B has a lot area of 9.23 hectares with approximately 194 meters of frontage on Rennick Road, and it's intended for residential development. Severed parcel C has an area of 9.58 hectares with 185 meters on Rennick Road. It's vacant and intended for residential development. The retained lands will retain an area of 14.4 hectares with approximately 505 meters of frontage on Rennick Road and water frontage on Vardy Lake. This is, the retained lands are developed with a single family dwelling and multiple accessory structures, including barns. So again, as described, the applicant seeking to create 5 separately conveyable parcels. Parcel A is intended for conservation uses and is intended to be sold to the NCC, the Nature Conservancy of Canada. Access to severed parcel A will be from the road allowance to the south. The remainder of the parcels are intended for residential development and will have access from Rennick Road. In regards to the subject lands or rural lands, public services facilities efficiently. The existing proposed uses are permitted within rural lands. The development's compatible with the rural landscape, and no new public service infrastructure is anticipated to be needed as a result of these applications. The subject lands are designated rural in the County of Lennox and Addington official plan, as well as the Township of Stone Mills official plan. The rural designation permits a variety of uses, including residential, non-residential land uses. Again, these existing and proposed uses are consistent with what's intended in the rural in the rural designation. The lands are adjacent to Vardy Lake and some areas of provincially significant wetland. Through this application, the applicant will need to apply to the Conservation Authority for any development within 30 meters of the Vardy Lake and within 120 meters of the provincially significant wetland boundary. There's sufficient area outside of these setbacks to accommodate future residential development. The subject lands are zoned rural, and there's sufficient area to meet the minimum frontage requirements for both residential and non-residential land uses. So based on this, it's my professional planning opinion that these severance applications meet the intent of the PPS, conform to the policies of the County and Lennox and Addington official plan, Township of Stone Mills official plan, and the provision of the township zoning bylaw, pending the noted conditions are satisfied.
Thank you, Emma. Questions, concerns from the committee?
Yeah, just a question. One of the conditions is that the property identified as PIN 45070-0206 be merged on title with the proposed retained parcel. What are we talking about here? Which parcel are we talking about?
Yes, through you, Mr. Chair, if you look to the screen, Cindy's pointing out areas of the point on Vardy Lake. It's my understanding through correspondence with the applicant's lawyer that these lands were kept as separate and held in trust, but function as one parcel, and to avoid having landlocked parcels at the lake, we're requiring that they merge with the retained parcel to provide sufficient access and recognize how they're functioning today.
So does that include just that parcel that's sort of completely separate now? Because it doesn't include the other parcel up to the north, does it?
My understanding is yes, it's that point there.
Just that point, that's going to be added to the retain. Okay, that's fine. I was just curious about that.
Okay. Need a mover and a seconder. Moved by Dieter, seconded by Bob. Any discussion, any questions from the audience? Any further discussion? Moved by Dieter, seconded by Bob. All those in favor? Carried. B 42-2023, Renix, again. Say. You've already given us the preamble, Emma?
Yes, yeah, the preamble would apply. This one's for severed parcel B.
Need a mover and a seconder? Moved by Aaron, seconded by Dieter. Any further discussion? Any questions from the audience? Yes, sir? Will you come to the table? Tell us your name.
I'm Mark Stad with the Nature Conservancy of Canada. My address is 2nd Avenue, Uxbridge, Ontario. Is that turned on? So I wasn't sure where I would be able to speak because there are multiple severances. I'm just here to speak on behalf of the Nature Conservancy offering support for this application. The family has been working with us to come up with a plan that conveys a large portion of the property for conservation, and we wrote a letter of support for the application. I'm just here to support it here today to say it's going to be a great thing to help support the health of the lake, and it has probably one of the last loon nests on the lake. So if you want loons in the lake, go for this. No, but I'm here to support the application, and if there are any questions, let me know.
Well, I guess it's already been passed.
That was the first one?
Yep.
Okay. All right.
Thanks for the speech anyhow. Okay. We had a move by Aaron and seconded by Dieter. All those in favor? Carried. B 43-2023. Emma again.
Yes, through you, Mr. Chair, this would be severed parcel C, and the same preamble would apply.
Thank you. Any questions, concerns from the committee? Questions from the audience? Need a mover and a seconder. Moved by Bob, seconded by Merrill. All those in favor? Carried. B 44-2023, 144 Rennick Road. Emma?
Through you, Mr. Chair, this application is related to severed parcel D, and the same preamble would apply.
Questions or concerns from committee?
No,
Audience?
no concerns. I was talking with Susie the other day, and she mentioned something about rezoning and everything, but I noticed all the parcels are going to stay rural, because you had mentioned rural residential, but no. Whatever is RR is going to be changed to RU, right? Where there was one parcel in there that's going to be changed, but the rest of it is going to be rural zoning, which is what you wanted. Yeah, okay.
Yes, through you, Mr. Chair. The condition of B44 is that the lands be rezoned from rural residential to place all of the lands in the rural zone to harmonize the zoning and appropriately regulate future development.
Okay. Need a mover and a seconder. Moved by Bob, seconded by Merrill. Any further discussion? All those in favor? Carried. You're done. Have a good evening. Okay, B30-2024, unaddressed Robinson Road.
Through you, Mr. Chair. Again, if it's acceptable to the committee, I'd propose to speak to B30 and B31 concurrently, as they're from the same land holding. So consent applications B30 and B31 are proposing to create a total of 3 parcels that are anticipated to be developed with future residential uses. The proposed parcels are considered via severed parcel A, severed parcel B, and the retained parcel, as shown on the sketch on the screen. Severed parcel A has an area of approximately 3.88 hectares with 100 meters of frontage on County Road 4, which meets the minimum lot area and frontage requirements for residential uses in accordance with the Township of Stone Mills zoning bylaw. The parcel has 190 meters on the Cataraqui Trail and is subject to a drainage easement in favor of the County of Lennox and Addington. Access to proposed severed parcel A will be provided from County Road 4 and will be required to be by a mutual entrance with severed parcel B. Severed parcel B has an area of approximately 4.3 hectares with 102 meters of frontage on County Road 4. This meets the minimum requirements for residential and non-residential uses in accordance with the Township of Stone Mills zoning bylaw. And again, access to severed parcel B will be provided from County Road 4 via mutual entrance with severed parcel A. The retained parcel seeks to maintain approximately 3.17 hectares with 161 meters of frontage on County Road 4 and 165 meters of frontage on Robinson Road. This exceeds the minimum lot area and frontage requirements for residential uses with the Township zoning bylaw. Access to the retained parcel will be provided by Robinson Road. So the subject lands are designated rural in the Township of Stone Mills official plan. The rural designation permits a variety of uses, including residential and non-residential land uses. The existing uses and the proposed residential uses are consistent with what's intended in the rural designation. Although presently used for agricultural purposes, the lands are not within the prime agricultural designation, and as such are subject to the policies of the rural designation. This is consistent with section 4.4.2 of the Township Official Plan, which indicates that prime agricultural designation does not include other agricultural lands which are not classified as prime agricultural lands. Limited residential development is permitted in the rural designation, provided that it retains the rural character, which is characterized by low density, large lots and frontages. And the severed parcels meet this test in my professional planning opinion, as they have an excess of 100 meters of frontage and exceed the minimum lot area requirements. Generally, the proposed severances represent a rounding out of existing development in the area and could be considered an infilling of existing development. I'll note that Schedule B of the official plan does not identify any environmental protection areas on the subject lands. According to Schedule C, the lands are within an area of high-risk source protection, significant groundwater recharge area, Gull River Formation, and potential karst topography. We've received correspondence from Quinte Conservation, who has no objections to the proposed consents, as due to the quality of topsoil on the lands, consider the likelihood of karst to be negligible. We'll note that we have required as a condition of a consent that a hydrogeological study be completed to confirm the quantity and quality of water available to support any future residential development. I'll just note as well that the official plan permits a maximum of 3 residential or non-residential lots to be created from a lot of record. So this larger holding is considered to be an existing lot of record. It was part of a previous application that adjusted the lot lines by way of lot addition, but the holding is still considered as one. So the property is eligible for these 2 additional severances. We did a review of minimum distance separation to confirm compliance with MDS. Our review found that the severed lots are adequately set back from nearby livestock facilities. Again, we'll reiterate that we're recommending that a hydrogeological study be completed and that well testing be done. And would just like to summarize and say that through my review of the applicable land use planning application or land use policies, it's my professional planning opinion that the proposed severances meet the intent of the provincial policy statement, County of Lennox and Addington official plan, and Township of Stone Mills official plan. So with the recommended conditions, it's our recommendation that the consents be approved.
Thank you.
Thank you.
Questions or concerns from the committee? Yes, Marilyn? Marilyn?
Turned on theirs, but not mine. Who would identify that there's karst in the area when they're building?
Through you, Mr. Chair. So karst topography is defined as a natural hazard under the provincial policy statement. So it falls under the purview of Quinte Conservation Authority. That being said, we have a condition for an acknowledgement clause built into the notice of decision that puts it on both the township and the Conservation Authority staff. And typically that's done at time of building permit when an excavation of substantial size is excavated to understand whether or not there is the presence of karst at that depth.
Thank you.
Anyone else in the committee? Questions? Concerns? The audience? Anyone ever in the audience? Yes, ma'am. Pardon me?
She can come forward and she has 7 minutes.
Yeah. Just remember what I said at the beginning of the meeting. You have 7 minutes.
Well, we'll try. Okay, there are two people who would like to follow me and as part of this presentation. Okay, this is an appeal to the Stone Mills Committee of Adjustment to refuse approval of applications B30 2024 and B31 2024. In addition, this is an appeal to the Stone Mills Committee of Adjustment to reconsider approval of applications B19, B20, B21, B22, B26, and B57 2023. All applications are on Robinson Road. Okay, now, we found some serious irregularities in the Robinson Road applications. So in considering the approval for those applications, B30 2024 and B31 2024 for Parcel C, Robinson Road, the Committee of Adjustment must base potential approval on the previous 2023 applications, B19, B20, B21, B22, B26, and B57. The previous applications involved 4 severances on Parcel A and B, and 2 lot additions involving Parcel B and C. These must be finalized before the granting of final approval for the most recent applications B30 and B31 2024. Now, at the September 27th and November 29th, 2023 Committee of Adjustment meetings, the 6 original applications were opposed by a group of residents for several reasons. And chief among them was that the development of prime agricultural lands, CLI classes 1 to 3, was not consistent with the provincial policy statement, PPS, or the language of the township official plan, OP. In recognizing that the township had previously zoned the subject land rural, the committee felt that they had no option but to grant provisional approval. The committee, the authors understand completely why the committee was compelled to make that decision. At the time of the above-mentioned meetings, many members of the public did not know a great deal about how consents are dealt with. We have come to appreciate the challenges faced by planners and by the Committee of Adjustment. The Committee of Adjustment holds an important role in assuring that development in the township proceeds in a manner consistent with all planning legislation. Without their oversight, consents and development would proceed in an uncontrolled and chaotic fashion to the detriment of all landowners and ratepayers. We value members' dedication to the process and their individual areas of expertise and experience. The committee can only make valid recommendations based on the information that is supplied to them for consideration. It is with this aspect of the process that we have found serious cause for concern in the approval process of the Robinson Road applications. The Committee of Adjustment was not provided with complete, accurate information, and these concerns are many, as we outline below. First of all, the Planning and Development Services staff report dated November 22nd, 2023, by the Manager of Development Services and presented to the Committee of Adjustment on November 29th, 23, contends that the subject lands are 3 separately conveyable parcels. Based on our research, records do not indicate this to be so. The Manager of Development Services has contended that the subject lands consist of 3 conveyable parcels and wrote in an email dated July 3rd, 2024, that the 3 parcels each maintain a unique municipal roll number. The parcels have been confirmed as being separately conveyable through the submission of a prior consents report completed by an Ontario land surveyor, end quote. However, the notice of application and public meeting supplied by Stone Mills indicates a single roll number, 1124-020-020-02900, and I'm not going to repeat that every time, okay? For all 3 parcels, as do the applications, both the original and the amended submitted by the owner. The Quinte Conservation Planning Review recognizes 2 distinct roll numbers for the total subject lands, and I'll just read the end numbers, 2900 and 3100. MPAC's website shows parcel A and B as a single parcel represented by the municipal roll number 2900, and parcel C as the number 3100. We have discovered no evidence of 3 separate municipal roll numbers. There are only 2 prior consents reports. The first one, dated May 30th, 2023, describes parcels A and B as the lands, and I quote, "The lands herein described was a single registered parcel of land." The second prior consents report refers only to parcel C. No documentation has been found indicating that parcels A and B are separately conveyable. It might be argued that parcels A and B have separate and distinct PINs or property identification numbers, but this is immaterial in determining conveyability. This judgment was made authoritatively by the eminent legal scholar Sidney Troyster, who said, "PINs are the invention of Terranet and its way of cataloging parcels of land. A single property can consist of more than 1 PIN to constitute a single property for Planning Act purposes." End of quote. And that's from the Planning Act and Why Lawyers Make Mistakes, page 6, April 3rd, 2017. No evidence has been found to corroborate the claim that parcels A and B are separately conveyable based on the methodology used by the Manager of Development Services or any other methodology. The committee was incorrectly informed. Okay, another concern. The above-mentioned staff report, page 1, documents the registered plan of survey 29R-9605 submitted in the 2023 applications. The survey submitted is not a survey of the subject lands. The submitted survey, in fact, is a survey of the lands south of the Cataraqui Trail. The reference lands that are the subject of the application are situated north of the Cataraqui Trail. The authors of this report were confused by a reference to Part 2 on the incorrect submitted survey as it is shown adjacent to the Napanee River. Had a copy of the submitted plan of survey been provided to members of the Committee of Adjustments, this error would have been immediately recognized as the surveyor who drafted the plan is a current member of the committee. Now, a drainage easement, 29R2312, is correctly noted on page 4 of the staff report. It is noted that the current staff report, the Committee of Adjustment on application B30 and B31, 2024, prepared by Emma Stuckey of Arcadis, does not reference the incorrect plan survey. It references only the registered plan 2312 for a drainage easement from 1990. Okay, I am going to hand this over to the next speaker.
Jacob Ellens from 2791 County Road 1, Camden East. There are further serious inaccuracies in the applications. One, as stated above, applications B22, 26, 57, and I know you all have copies in the committee, so I won't say all the numbers, are identified by incorrect municipal roll assessment numbers. B26 and B57 actually impact different parcels, so two separate roll numbers must be identified. A question we have is, was the Committee of Adjustment informed of this discrepancy? Second, the ownership of parcels identified in application B22, 26, and 57 is incorrectly attributed. Ownership of all parcels, including parcel C, is attributed to numbered company 165 and on. However, the correct owner, according to the Land Registry Office, LRO, the records, is numbered company 100 and on. The current applications, B30 and B31, correctly identify the owner of parcel C as numbered company 100 and on. No transfer of ownership occurred, according to the LRO records. These are separate corporations, and though they might have the same listed officers, other individuals or entities with an interest in those companies are not necessarily identified. It doesn't matter who the officers or shareholders are. Corporate law deems the companies to be completely separate legal entities. Such companies may be comprised of various unnamed shareholders, such as small or large investors, Canadian or multinational companies, foreign corporations, or simply one or two other persons. It's important to note that because the numbered companies, 165 and 100, may feature different shareholders or backers, they must be viewed as separate entities with possibly different interests. Again, the question is, was the Committee of Adjustment aware of this? Number three, all 6 applications made in 2023 claim the proposals are consistent with and conform to the provincial. We've heard that again tonight. Proposals, in fact, are inconsistent with the PPS. The subject lands are categorized by the Ministry of Agriculture and Rural Affairs, MAFRA, as Canada Land Infantry Class 2, and therefore are identified as prime agricultural. The PPS does not permit severances on prime agricultural lands and is the ultimate authority on land use policies. Municipalities' official plans must be consistent with the PPS. The planner, Lindsay Mills, hired by the subject landowners, made the statement that, quote, the new lot creation is consistent with the 2020 PPS, which promotes residential lot creation in rural lands, but neglected to mention that the applications are not consistent with sections of the plan that refer to classification and protection of prime agricultural lands and prohibit severances and development for any non-agricultural related uses. Again, is the committee aware of this? Applicants were required to provide assessment roll numbers for abutting lands. Parcels A, B, and C abut. This requirement was not completed on the original May 30, 2023 applications. There are legal implications in the transfer of abutting lands. Again, was the committee made aware of this? 5, applicants were required to complete a written authorization on the application form in the event that the applicant was not the owner of the subject land. This is not completed on the 2023 application forms. Was a separate document submitted in reference on this issue, to this issue? However, this presents a difficulty in that the applicant, 1652703, was not the owner of parcel C, though the applicant claimed to be such. 6, page 6 of the application form requests information on the mortgagee for the property. The mortgages are within the purview of the Committee of Adjustment, but this section was left blank, so we won't go on with that. 7, additional information required as part of a complete application. Quote, for an application to be deemed complete, the following minimum information must be submitted as part of the application, unquote. This is the Stone Mills application form. 1, a fully completed consent application form with all questions responded to. 2, a sketch of the proposal, including the approximate location of all natural and artificial features, including but not limited to watercourses, wetlands, and wells. Quote, that quote, in the applicant's opinion, may affect the application, unquote. The following items were not a part of the submitted sketch. 10 wells were drilled by the current owners on a significant groundwater recharge area prior to any application being submitted. The recharge area is mapped in Stone Mills zoning bylaw Schedule 15. Sensitive groundwater feature areas and is labeled as a high-risk area. Drilling rigs were on the land and visible from County Road 4 for the better part of a year. It should be noted that development of the lands had been proposed by staff as early as 2020. The applicant did not include any of these features on the submitted sketch. The manager of development services in his report to the committee noted the existence of the recharge area, but did not insist on its inclusion on the submitted survey sketch. Neither he nor the applicant noted or reported on the existence of 10 wells in the recharge area. Number 3, identified as 8 on the application form, a transfer of title of the lands if the lands have been recently purchased or at any time where the township records do not indicate the applicant as the registered owner. Question: were staff and committee members aware that the applicant 1652703 was not the owner of parcel C? D, the process of severance and lot addition in these applications appear irregular. The process attempts to sever and reorganize land. The applicant does not have title to parts of the land being reorganized. As mentioned earlier, the applications for severances and lot additions involving parcel C were applied for under the wrong ownership. 2 of the applications involving severing of land from one parcel and adding it to the parcel owned by a different company. This would involve a transfer of ownerships. Was the committee made aware of the fact that the lands were not under the same ownership? At the November 29 meeting of the Committee of Adjustment, a local resident expressed his discomfort with the plans and suggested that some quote unquote massaging might have been involved. The manager of development services replied that the application had been quote favorably interpreted unquote. As to the current applications, just one more paragraph, as to the current applications, the submitted severance sketch refers to lots in parcels A, B, and C as being previously severed. These severances have not received final approval, though the severance sketch would appear to indicate that they have. In addition, the quote-unquote previously severed lot bordering on Robinson Road and straddling the boundary between parcels B and C was a result of the questionable lot addition B26-2023. The separate parts being considered are, as stated earlier, owned by 2 different numbered companies. The current application for severances, B31, B31 2024, and B32, assumes that parts of parcel B is already part of parcel C and vice versa. Yet all of parcel B and all of parcel C are owned by separate corporations. Thank you.
Good evening. I'm Wayne Goodyear. I live at 285 County Road 6 in Yarker. And I am doing a section in your copies from Section E, Development of the Lands. Okay. And the comment that it's been favorably interpreted is what this picks up on, indicating it was encouraged by Stone Mills Council and staff from the inception as a preferred area for development. The current owners of the Robinson Road lands have invested considerable sums in their development plans. Expenses included the purchase of the lands for almost $1 million and the drilling of 10 wells on the property. They've had the expenses of hiring a planner and a surveyor, and they were required to pay the requisite fees for development applications. They're required to pay for a hydrogeological assessment of the land in question and will no doubt be required to construct several additional wells in order to service the 9 lots applied for. Most of these expenses could be anticipated in advance. The current owners were, in fact, not the owners of the subject land when they began drilling wells almost 2 years ago. In their willingness to invest more than $1 million in this project, they had to have had some confidence that their plans would be favorably interpreted. Indeed, it appears that council and staff had an interest in assuring that development on these lands should take place. In fact, according to a letter from Gordon and Elaine Galbraith to the township, it was in February 2020 that the township office had taken the initiative and approached the Galbraiths, who then owned part lot 24 and part lot 25, to ask if they, quote, would consider a subdivision on the above mentioned land, unquote. The Galbraiths replied that they, quote, had never considered this, unquote. They subsequently met with 2 staff members, Jason Sands and Jeff Thompson, and, quote, at that time they discussed a few options of how a subdivision could be laid out, unquote. At the conclusion of the letter, Galbraiths expressed concern about opposition to the proposed development. Quote, considering that Stone Mills Township made the initial suggestion of a subdivision, unquote. And this is from the letter from Gordon and Elaine Galbraith to Building Department dated 29 July 2024, correspondence file concerning lots 24 and 25, Stone Mills Township Civic Web Portal. Council's interest in developing this land was also acknowledged in a letter dated October the 2nd, 2022, from Councillor Lalonde to Mr. Sands, referring to a 2021 conversation between them concerning the Robinson Road lands. This letter states, quote, "You and I spoke about the parcel of land when it was being considered for a fairly large plan of subdivision, and I believe at that time, about a year ago, that there wasn't enough water for a large plant," unquote. Email from Councillor Lalonde to Jason Sands dated October 2, 2022, correspondence file concerning lots 24 and 25, Stone Mills Township Civic Web Portal. The Galbraith letter has been corroborated in correspondence from developers Emil Nyborg and his father Theo Nyborg, sent to each councillor as well as to some staff. This letter is now part of the public record of advice to council on township land development. The Nyborgs wrote on 19 February 2024 that staff from the township approached the former owners of the property, requesting them to consider abandoning the farming practices on the lands and building a subdivision. This is the reason why we first entertained the idea of purchasing the lands from the Galbraiths, unquote. That's a letter from Emil and Theo Nyborg to Stone Mills Township, 19 February 2024, correspondence file as above. The Nyborg letter makes it clear the initiative had been taken by the township to encourage development on that land. As the Nyborgs revealed, their knowledge that the township had first suggested that the Galbraiths develop lots 24 and 25 was, quote, "the reason why we first entertained the idea of purchasing the land from the Galbraiths," unquote. Was the Committee of Adjustment aware that staff and council were encouraging development on that particular area of the Robinson Road? Section F, why was the existence of 10 wells on a significant groundwater recharge area not included in the staff report to the committee? At the February 10, 2024 meeting of Stone Mills Council, our group reported on the improper construction of 5 of the 10 wells drilled by the current owners of the property. The wells were drilled from August 2022 to July 2023, a period of approximately a year. Several of the wells were to be abandoned because of contaminants. Well Regulation 903 requires that such abandoned wells be decommissioned immediately because of the risk of groundwater contamination. The Stone Mills official plan requires that abandoned wells be properly decommissioned. To quote the matter, the township will require conformity with Ontario Regulation 903 as amended with respect to the construction of new wells. Abandoned wells will be required to be properly decommissioned. Section 5.13.2.I, Stone Mills official plan. They were not. The Ministry of the Environment and Conservation and Parks consulted with all parties and expedited the proper decommissioning of these wells. The decommissioning started in the week of July the 1st, 2024, and was to be completed in the weeks following, according to the MECP. And that's almost 2 years after the drilling commenced, according to the MECP. Why is this a concern? Well, because the Robinson Road property lies, in fact, in whole within a large, huge, significant groundwater recharge area that charges the aquifer supplying Camden East and perhaps lands down gradient of that. Recharge areas are especially vulnerable to contamination. This is a concern when there is the possibility of a contaminant in the designated area. Improperly decommissioned wells and unsealed wells provide a direct conduit to the groundwater or aquifer below. Salt from unopened seams or roads can leak immediately into these spaces and travel the length of the exposed casement to the aquifer or into other exposed seams. Surface contaminants also can drain into the unsealed spaces, and heavy metals, often naturally occurring, can transfer from one open seam to another and to the aquifer when wells are drilled and improperly sealed. And a side note, in fact, all professional studies on groundwater recharge areas list well drilling as a potential risk to them. Okay? Farming practices, if properly carried out, are normally safe, but farming operations carried out over improperly constructed wells in a recharge area introduce a variety of contaminants into the wells. The owners of the wells contracted farming operations on the subject land over 3 summers, that these wells, over the 3 summers they were in existence. Operations involved cultivating and spraying up to and over abandoned well areas. There was no mechanism for oversight from the township to ensure that these wells are made safe, despite the language recommending the same in our official plan. The township has not passed a procedural bylaw to enforce compliance with the township official plan or with Ontario Regulation 903 concerning well conduct. It's unclear where the responsibility for well drilling and decommissioning lies. The township has primarily responsibility for water quality, though. 5 of the 10 wells had to be abandoned. An 11th well drilled by a previous developer was also abandoned due to heavy contamination. That developer pulled out his proposed involvement with the project as a result of that. This is a drilling success rate of 45% thus far in acquiring potable water supply. As you know, a total of 9 lots are to be created by these current and previous proposals. It appears 5 wells currently remain. With a current success rate of 45%, how many more holes will have to be bored into a high-risk area to ensure there's sufficient potable water supplies for 9 residences? Did the committee receive any information at all about that well situation is our question. Section G, administration of the oath. The applicants, in submitting their applications, signed an oath that solemnly declared, 1, that all statements contained in this application are accurate and true. 2, representatives of the Township of Stone Mills, as well as representatives from other levels of government or any agency thereof who have been deemed to have an interest in a matter arising from this application, are authorized to enter upon the lands and to conduct any inspection necessary that may have an impact on a decision relating to this application. And 3, makes this declaration conscientiously believing it to be true and knowing that it is the same force and effect as if made under oath and by virtue of the Canada Evidence Act, unquote. It was not complete, nor was it accurate nor true. This statement was signed by an officer of 1652703 Ontario Inc. on every application for the Robinson Road development submitted in 2023 and witnessed by the staff acting CAO, who at that time is the Commissioner of Oaths for the township.
Wayne, are you close to winding up because you're over 8 minutes?
Thanks, Bob. Yeah, I am. As a result of staffing shortages, a single staff member, Jason Sands, was required by council to fulfill the responsibilities of a number of staff positions: acting CAO clerk, the manager of development services, municipal planner, and commissioner of oaths. This required that a single individual was required to promote development on the subject properties, provide full briefing information and recommendations to the Committee of Adjustment, and administer the oath certifying the completeness and accuracy of applications. For council to have required a single individual to fulfill these multiple roles was simply unfair. These roles often require detailed oversight of the processes. In essence, the council required the individual to provide oversight, in fact, on his own work. This has unfairly placed this individual in jeopardy. We would very much appreciate a reply to this submission, and we request that you extend to us the courtesy of investigating steps to remediate the issues described here. Also, please address any errors or inaccuracies we may have made. We have striven for accuracy in the research behind this document and have spent countless hours in doing so. But we are human, as is everyone else referred to in this presentation. People make mistakes. We would not have invested our precious time and energy in it had we not thought our efforts were for the betterment of the community of Stone Mills. And in closing, this is personal, my comment is we are working with developers and others that are known members of the community and in many ways trusted. Coming investments out of Toronto may not be so agreeable. And so these concerns need to get tidied up. Thank you very much.
Anyone else have any concerns or questions? Yes, Marilyn?
I just noted on page 7, where you were saying that there was a letter from Gordon and Elaine Galbraith to the building department dated 29th July 2024. And you were noting that people do make errors, and I assume that because we haven't quite reached that.
We put that in proof.
Here you go. To prove that everyone makes errors.
Thank you.
A question of that. The only other question I have, I was looking at protecting our drinking water sources. And this particular article talks about Source Protection Committee. Do we have a Source Protection Committee?
Jason?
Through you, Chairperson Clancy, no, within the township of Stone Mills, we don't have one at the municipal level. Source protection committees are typically associated with a drinking water system supply, like a municipal drinking water system infrastructure. So as we don't have one in our jurisdiction, we do not have a source water protect or a committee set for that purpose.
Thank you.
Mr. Chair, if I may, I apologize. I forgot to mention this at the onset. I recognize Ms. Galbraith is with us this evening, and correspondence was received this morning in hard copy form. And I wanted to inform everybody in the audience and anybody who's watching on YouTube that that has been provided for the committee's consideration. So copies were passed out and it is there for your awareness. So thank you for that, Ms. Galbraith.
Yes, Aaron?
I'm just wondering if the applicant wants to speak to the status of the wells. We keep hearing the question in terms of the status. Can we have an update, please?
Hello, everyone. I'm Neil Nyberg. Yeah, so the 5 wells have been decommissioned that weren't good. I'm not entirely sure why they were being called contaminated. They weren't adequate for potable water. That's all it really came down to. Not enough flow for Jason can correct me on this. I think it's 3 gallons a minute or in that ballpark that it needs to be. Or just the potability wasn't good enough. There wasn't any contaminants per se. It was all naturally occurring things. It's just not safe for consumption.
Through Mr. Chair, 3.6 gallons per minute is the 905 spec for Ministry of Environment for minimum threshold on a potable well. Yes.
Anything else? You're thinking, Aaron, go ahead.
I think Dieter has a question. I'll think while he asks his question.
okay.
Okay, Peter.
One of the points that was raised in the presentation mentioned the previously severed parcels. So looking at the severance sketch, there's those 3 previous parcel adjoined severed proposed several parcel B. How the fact that they've never been finalized and they haven't been conveyed yet, how does that affect the the application for parcel B?
Through you, Mr. Chair, unfortunately, Member Everhart, I can't see through your laptop, so I can't see your screen, but I'm looking at the one on the wall.
That one there, yeah. You're talking about the 3 smaller previous severed parcels on Robinson Road that adjoin the proposed parcel B, which goes out to the county road. So they've never been conveyed yet because the severances haven't been finalized. So and the concern that was brought up is that, so how does that affect parcel B? Like the ownership of parcels, those 3 severed parcels, are they still not? I don't know.
Yeah, sorry.
I think you know what I'm getting at. But
I think I understand your question. In short, in terms of the maximum number of lots created on a single land holding, from that perspective, we've interpreted it as though that lot would have been created, so it would be considered so that we can ensure that we're not exceeding that official plan policy upset limit of number of lots created. We recognize that it has not been created. We've received no conditions with respect to satisfying those hydro-G studies, well records, any of that sort to date. However, this sketch has shown it so that we are being consistent with what was provisionally approved and what is being considered through this process. If the applicant has not or does not continue to satisfy those conditions and those previously approved severances lapse, for example, then that lot creation fronting County Road 4 and Galbraith Road would have essentially 1 additional severance that could then proceed, because that smaller one that you're making reference to fronting Robinson would then not have been created.
Anyone else? Yes, Merrill?
there were quite a few references to the fact that perhaps the same numbered company, even though they might have the same officers, executive, whatever, that there were actually two separate companies that owned those various parcels. Just wondering if we could get some clarification of those.
Through you, Mr. Chair, I'll let the applicant speak to the numbered companies. Essentially, from a municipal review perspective, it's irrelevant if the owner is a name or a numbered company. It doesn't have a bearing on the land use planning merits of an application, but if the applicant chooses to provide any information with respect to the numbered companies, I would leave that for them.
Certainly happy to clarify that one a little bit. So when we first purchased it from the Galbraith, it was under the 165 company for all three parcels. When we looked at our full plans on what we wanted to do, and particularly the fact that the two parcels abut each other, we wanted to keep that separate because we didn't want them to merge and become one parcel. So we decided to utilize one of our other numbered companies, the 1000, so to speak, which is exact same ownership, same shareholders, same director, same everything. I can say my partner right behind me, that's it. There's no other shareholders. There's no ghosts from Toronto or from China or anywhere else.
There was reference to the township seeking out the landowner to develop this property. Jason, can you provide clarification on the township's role in encouraging development in the township?
Yeah, certainly. Thank you. So there's some information contained within the presentation that's accurate, and there's some information that's not so accurate. Firstly, municipal staff met with the former owner, the Galbraith, respecting this land holding, as we were informed that their future of farming with this land holding was in question. And at the time, the township was working with the county of Lennox and Addington in attempting to secure a viable location for affordable housing project, an affordable housing project in our community. So at the time, CAO Brian Brooks, myself, and Jeff Thompson, the three of us staff met with Mr. and Mrs. Galbraith to understand what their future intent was with the land holding. It was a single meeting, and we understood very quickly from that meeting that they didn't have any intent in conveying that land or developing that land in conjunction with the county and or the township for what we were seeking in being a potential location for residential intensification. And that was the single meeting that was had. So that's sort of the background. And there was never anything brought forth publicly to council because we did not essentially get to that stage of negotiation or purchase agreement of purchase and sale or any of that sort. So I hope that provides some clarity.
Thank you.
Councilor Merrill?
Just concerning that, why would the township have initially approached the Galbraiths? What was the reasoning behind it?
Through you, Mr. Chair, I don't recall all of the reasons, but one of the reasons was one of the drivers for the county in understanding where a viable location would be for a project was one that was close to market in terms of amenities. So from a walkability perspective, of course, this land abuts the Cataract Way Trail. From a services or an amenity perspective, it's in very close proximity to the hamlet core of Camden East, which has some commercial uses that can be essentially within the 600-meter or the walking distance that we use from a land use planning perspective in assessing that distance. And from a official plan designation perspective, from a zoning perspective, we understood that there was policies that ought to be completed, but we saw those as being possibilities for consideration of development. So for those reasons, it was initially looked at as being as a potential site.
Anyone else? Yes, Dieter?
Yeah, just ask the applicants, what are your plans for those 3 lots? Is anything in your plans? What, like, do you have plans for these yourself, or are they just going to be put on the market and sold?
At this point in time, we don't really have any immediate plans, just given the way that the political landscape's going with trying to reclassify lands and whatnot. We wanted to protect our interests to make sure that we had some potential to do different things with it. So given that there's that movement for class 1, 2, and 3 soils to change how you are allowed to subdivide things, we got ahead of it and said, okay, now we're gonna make it into 3 parcels so that we have a little bit more future available to us.
Okay, thanks.
Yes, Merrill?
Could we have clarification again on the prime ag designation as opposed to class 1, 2, and 3? And I was looking at the provincial guidelines, and seemingly you have to have large tracts of land to become prime ag. Just, that's what I was reading.
Through Mr. Chair, I'll start and I'll let Emma provide her opinion from a professional planning perspective. So the provincial policy statement, as we know, differentiates prime agricultural lands from rural designated lands. And within the prime agricultural designation, I believe it's section 2.3 of the prime ag policy set in the provincial policy statement, the 2020 provincial policy statement, there's inclusions as to what they consider to be prime agricultural lands, starting with specialty crop areas, moving through 1 through 3 soils, and so on. So there is specific considerations as to what factors into being designated prime agricultural lands. Of course, then there is other policy sets that are applicable to rural lands that are designated rural. And there's often policies, and I don't have them in front of me, that speak to the protections of agricultural lands that even are outside of a prime agricultural designation, but fall within the rural designation. Yes, I understand through the CLI, the Canadian Land Inventory Mapping, or we understand that this subject property contains class 2 soils. However, it is not designated under the provincial policy statement as being prime agricultural farmland. So we're not afforded those same levels of policy rigor in the PPS as you would be if it were designated. To your specific question, Member Fenwick, regarding large tracts of land, that is often a component when assessing whether or not good soils are also then protected under a prime agricultural designation. And that's completed through a LEAR study. So there's a LEAR study considers 2 different factors, and that's soils as well as fragmentation or existing development, and puts together whether or not this tract of land would meet those requirements to necessitate the designation of prime ag for protection purposes from rural residential development such as this. There's a history in the township that I don't think is appropriate form as to what's happened and how we've gotten to where we're at with respect to what's protected and what's not. However, we as a corporation and council motion have requested that the County of Lennox and Addington, which are currently in the process of completing a comprehensive, complete a LEAR study that's county-wide that would assess both the soil classifications as well as the fragmentation component that factors into that assessment, so that we can have a reconsideration of what is protected through a prime agricultural designation in the entirety of our township.
Thanks for that clarification.
Yes?
I would like to say something in opposition to that. First of all, prime ag lands are defined as classes 1, 2, 3, and we have a significant amount here in the county. We have 23,000 acres of prime agricultural land. Only 500 acres of them are designated as prime agricultural. The chances of us having a Lear study approved is not very high. For example, the county has already put off the whole topic of a Lear study until next year. Now, the Lear study identifies prime agricultural areas based on the classification, the Canada Land Inventory classifications of soil as 1, 2, 3. And we have a great deal of that in the county. And on top of that, we have plenty of other land which isn't categories 1, 2, and 3, which could be built upon. But no matter what you say, our OP here in the township does not have authority over the provincial policy statement. So for our township to say that the provincial policy only applies within the confines of the prime agricultural area as defined by the township is incorrect. In fact, the prime agricultural area that's been defined by the township mostly contains category 4 soil, which isn't necessarily protected, but could be protected after a Lear study is done. But it's not likely that you're going to get that Lear study. And once it is approved, it takes a while to complete it. And the Lear study will bring in other things as well. It will not only include categories 1, 2, and 3, which are already defined. It's based on the Canada Land Inventory. Those are already defined. The Lear study will take into account other areas around that may not be 1, 2, and 3 and include them in a prime agricultural area because they have connections to the farming that goes on categories 1, 2, and 3 soil. They will even consider that forests are category 1, 2, and 3 because they have the potential to have, and they have good land, and they have a potential for the future, which is really important in the situation we're in now, where our agricultural land is going to become more and more important with climate change. In fact, as land in the south of the United States and other areas becomes less arable due to drought and so on because of climate change, some of our farmland is going to be more and more valuable as time goes by. I have a map which will show you. I'll run out to the car and get it if the chair would allow me to do that, and I will show you exactly where the categories 1, 2, and 3 are in the county.
I said at the beginning of the meeting that you only would have one chance. You've had the second chance.
I've had my chance. Well, I'll bring it in case anybody wants to take a look at it later, okay? So,
That's fair enough.
thank you, Mr. Chair.
You're welcome.
Jason, I still have a question for you.
Have any questions? Yes, Dieter,
Yeah,
sorry.
sorry. I'm still not clear. The proponents there said that provincial policy statement does not permit severances on prime agricultural lands. Municipalities' official plans must be consistent with the provincial policy statement. So how do we reconcile this in this area? Like, does our official plan just ignore the provincial policy statement, or how does this all fit in? I just don't understand.
Through you, Mr. Chair, no. The short answer, in my opinion, is our official plan doesn't completely ignore the provincial policy statement. However, in my opinion, there's a reassessment that needs to be completed, and the reassessment is through the completion of a Lear study. And the Lear study would do more, would complete it via a more comprehensive review as opposed to simply looking at the soil classifications. Soil classifications, as I mentioned, is one component. It's a 60-40 split when you give consideration to what goes into that assessment. So to look at a soil class and say it's class 2, so that means it's prime agricultural land, it is misleading. There is an additional aspect to that that's not being considered. We have essentially come to a disagreement in opinion. We have the opinion of Arcadis, who are representing the municipality through registered professional planners, myself. We have MMAH, Ministry of Municipal Affairs and Housing, who are registered professional planners, as well as Ontario Municipal Affairs at OMAFRA, who are registered professional planners, as well as our county of Lennox and Addington, who have a registered professional planner. All of which who have confirmed that this property, although it has one Class 2 soils on a CLI map, it's designated rural. It does not garner the same level of protections as you would if it were a designated prime agricultural land holding. So I've not seen an opinion or a professional position from a registered professional planner to confirm that the 7 of us are incorrect in our interpretation.
So you're saying because the township has not designated this as prime agricultural, we're kind of stuck with the rural and this kind of stuff. Just as a aside, I was asked by a landowner in Loyalist Township whether he could get he just bought 50 acres and he wanted to sever the house out, because he didn't need the house. I contacted the planners. I think Erin, you gave me the information, and she looked it up. The first thing she said, that's prime agricultural, you can't have a severance. So, I suppose maybe we'll have to work on and designating, prime agricultural in this township and putting it in the OP, but as it stands now, we don't have that protection.
Anyone else on the committee have any concerns, questions? Yes, Aaron?
Obviously, we're in a time where, the information we have doesn't have this land designated prime ag. While we're waiting for mapping to be completed, a study at a higher level, is there an option for site-specific assessment to determine that it's not prime ag?
Through you, Mr. Chair, short answer, yes. In my opinion, there's absolutely an opportunity to look at it at a site-specific level. Every Planning Act application that's received in the township is looked at a site-specific level, and this one has been to that degree. The report before the committee this evening, written by Arcadis and Emma, did that assessment, and it looked at this from a site-specific level as to what levels of protection and policy we have to support, deny, or defer an application that we've received. As many of you are aware, the Ontario Land Tribunal exists in the province of Ontario, and any decision of this committee and or this council can be reconsidered by that tribunal. So one of the positions that a registered planner in the province must take is, are they able to defend the recommendation, not the decision, the recommendation at that tribunal? So that's one of the key considerations that my extension, my consultant extension, Emma, has completed through this as, from a site-specific level, what policy protections are afforded to this landholding to say or deny or approve what's before us today. And I'll let Emma speak to the report, of course, but the report has confirmed that based on the policies that we have in effect today, the proposal is consistent with and conforms to.
Through you, Mr. Chair, I'll just add that currently in the township's official plan, and especially specifically in the consent policies, there's not sort of policy that could be relied upon to request an additional soil classification assessment to consider the lands as prime ag through this application. So just wanted to clarify that piece. And yeah, just say that through this review, considered the policies of the day, it's currently designated rural, assess the proposal in front of us, under the rural designation and consent policies, and yes, prepared the report and included my recommendation based on that. Would agree generally with what Mr. Sands spoke about with respect to like history of the PPS and how or how not lands are designated prime ag versus rural, and would just reiterate that yes, my assessment considered it as the policies of the day, and ultimately my recommendation would be to approve.
If I may.
Go ahead, Jason.
Member O'Gara, I apologize. Many of the folks in the room this evening will be aware of this, but for the committee's consideration and knowledge, I'd like to just provide a 2-minute comment on this end. You heard earlier this evening that the applicant specifically made reference to advancing these applications because of the concern that there might be a change on our policy landscape from an official plan policies perspective and or a zoning perspective on how we're going to regulate in the future, notwithstanding a Lear study that may reassess and redesignate lands in the township. We have before council and members of the public draft official plan policy and draft zoning policy framework that have been, or that is out for public comment, is being considered as what's being quoted as an interim measure until that study is completed, because we recognize that there's a time frame associated with it. So to the comment that Emma had made earlier of we don't have that ability right now to say this appears to be very functional agricultural land. It appears as it's class 2 in a soil map. We want you and require you to provide an agricultural assessment completed by an agrologist, for example, to prove the functionality does not exist, so that you have the ability to subdivide for estate residential type yachts. That is consideration, that type of consideration is within that policy set that may be coming into effect in the future as an interim measure. So I just want to be clear and open that we are considering those types of things. We're still accepting comment on those types of policy changes. And I think largely, as the applicant had confirmed, that is really the driver for these applications on this landholding, because of those unknowns that may exist in the policy set moving forward.
Bob, you had a question?
Yeah, to Jason and Emma, is there anything in this report you would be concerned if you had to defend it, if it was challenged?
These comments?
This one that they presented tonight.
I'll go first. My first comment is it's unfortunate that it landed on my desk at 4:59. I didn't receive this 2 days ago, so we kind of came unprepared this evening with blindsided on the comments. In hearing the comments, no, there's no significant single piece that causes me great concern. I think it would be helpful for committee and maybe any of those in the public if I use the screen to show the lot fabric, because I think that's causing some question. I believe there may have been some typos on notices that the members of our community have accurately picked up on from a roll number perspective, and that's caused confusion. But I think I can explain those fairly concisely just looking at the screen. But to your short question, Member Sergeant, no, there's nothing glaring that I would be concerned under cross-examination at the Ontario Land Tribunal.
Want to put the same question to Emma, Bob? Go ahead, Emma.
Yes, through you, Mr. Chair. Just will recognize, my involvement on this starts through the processing of B30 and B31, and have no concerns with comments raised on those applications in this report.
Yes, Jason.
My colleague, Ms. Hike, is going to bring up the GIS mapping, and I think it'll help because of the roll number question, and I don't know the page reference, but it, and the error that existed on that public notice, so when she gets this up on the screen, and I apologize for those of you watching on YouTube, we're not gonna be able to see this, but, well. So the question of number of lots is important because the question of number of lots determines how many severages you can ultimately have because it's tied to individual land holdings. So in the presentation, I think my peers, because it's, and I'm going to use the short form like they have, and the roll number, this roll number for this land holding is different than the roll number applicable to these two pieces of land. Well, excuse me, it's difficult.
This isn't like a whole house.
This one. And
I'm not even
so what I'm trying to say is, there's a roll number here, and I have a problem. There's a roll number that applies to this, and then there's a single roll number that applies to these two properties. But it's three separate land holdings because this single roll is segregated by municipal road allowance. And Mr., as pointed out, Mr. Everhard, our committee member, actually surveyed this property, I don't know, a decade or two ago. So he could probably speak to this better than anyone in the room. But this individually separately conveyable, subdivided naturally, same as a road from this land holding, so individually separately conveyable. So it's 3 plus retained, according to our official plan policy section 752. Same 3 plus retained, and same 3 plus retained. This gets a little bit confusing, and I feel like I'm being a little bit misunderstood when the language in the report saying favorably interpreted. I disagree with the language, but I won't go there. It's the lot addition. I made that comment in reference to this lot addition piece because this parcel here technically would be permitted to have 3 severages plus the retained, but to make up the retained parcel, there's a portion of this being added to it because it was insufficient with respect to frontage and area. So I don't remember 9 months ago my language if favorably interpreted, but that's what that was in relation to. So 1 parcel, 2 parcel, 3 parcel. I have confidence that this is a land division. It's an unopened municipal road allowance. It's still within the meaning of the corporation. So this subdivides these parcels, and this is in a full separate roll number. I apologize we couldn't show that on here.
Those parcels on, would have different PIN numbers on the actual Terranet stuff. And roll numbers are a completely different animal, the fact that one roll number includes 2 parcels separated by the road allowance means they're the same owner, but they're 2 legally separate parcels because they're separated by the road allowance. So that's why they have the same roll number. Okay.
Okay. Any committee have any more concerns or questions? You had your turn. No, no. Back there in the back.
My name's Miles King. I live at 2812 County Road 4, just north of Robinson Road. Now, where you're talking, they was saying about a ditch along in through the field. That was put in there because on the other side of the road, there's a natural spring in there. You know what I mean? And there's a pond in there and it all drains down, and that road, if you didn't have that ditch, the road would turn into a swamp. You can't drive in there, you get stuck. I was born and raised there, so I know what I'm talking about. And I don't think that ditch should be filled in. Otherwise, the township's gonna be screaming about have to fix that road and everything else. That's all I got to say about that matter.
Go ahead, Jason.
Through you, Mr. Chair, thank you, Mr. King, for the comment. It was more, so the applications this evening are applicable to the parcel fronting County Road 4. And I recognize that the ditch in question is majority on the parcels to the west of this land holding as opposed to the parcel under question this evening. The applications that were approved in November of 2023 had a condition that made the applicant essentially realign that ditch or that natural water, that man-made water channel to become an extension of our ditch along Robinson Road. So our public works manager who oversees roads and drainage for the corporation has worked with the applicants on site to understand and design, and not design, but understand how that could be designed. And it's been included as a condition in that previous approval. So before any of the final approvals would be offered or granted by the corporation, that work would have to be completed to the satisfaction of essentially our municipal engineer to ensure that there's no adverse effects on future development, nor that there's any adverse effects on our taxpayers moving forward in having to deal with something that was missed or not adequately addressed through the development process. But thank you very much.
Well, you gotta think, look at this, there's about 3 or 4 houses past that, where that water goes in. And that's gonna screw everybody else that's on in Paso. Like the guy that owns Jack Boat's old house. And then there's been 3 or 4 other houses put in there. Between the first house and the second house, that's all swamp. You can't build in there, you never hit bottom. You wanna play in the mud, go ahead, you take the chance to look at the ministry.
Okay, we acknowledge. Committee members, I'm looking for a motion to either approve, deny, or defer. Yes, Merrill?
I'll make a motion to approve. I don't see anything. I'll make a motion to approve. I can't see anything that would tell me that I can't approve this. Unfortunately, and I understand the concerns, and I am looking forward to some future studies that may change that, but at this very moment, we don't have anything that I can see that says to me that I need to defer it or to deny it.
I have a motion by Marilyn to approve. Do I have a seconder?
Yes, but I have a comment. I go along with what Marilyn's saying. I also take into the fact that both the planners are very confident that everything you've done is right. So I will second that motion.
Any further discussion?
Yeah, just, I just want to make a comment on the conditions that have been imposed on these severances. There are 10 conditions that have been imposed on these, and the ones dealing with wells and Hydro G and the groundwater protection stuff are extremely comprehensive. And I have to commend Jason, I guess, for putting all these things in. So it's quite an onerous thing that's been put on the developers for this. But I think it's important that that you note the conditions that have been imposed in regard to water concerns on these applications.
There has been, I think, very well looked at. Because with the conditions that are there. Okay, I have been moved by Marilyn and seconded by Bob that it be approved. All those in favor? Carried. Thank you. P 31-2024 unaddressed Robinson Road. This is the mate to the one that we have just had discussion on. Any further discussion by committee members?
Yeah, just a letter that we were given by Fern Galbraith. Some of her concerns. The one I just want to make mention of is that she notes that there's no well on the retained parcel, but one of the requirements is that there's a well on the retained parcel as well. They have to drill a well on the retained parcel as well.
Need a motion to either approve, defer, yes?
No.
Bob? Move to approve?
Yes.
You second it, Merrill? Any further discussion? All those in favor? Carried. Thank you. Any other business by committee members? Yes, Bob?
Peter.
Oh, dear. Sorry.
I just want to make a recommendation on where we do multiple severances. That would be nice if in the summary somewhere it says that application B blah 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 is actual parcel A on the severance sketch. Can never figure out what we're talking about, which one we're dealing with. So I would just make that a recommendation, perhaps, that just an extra little clause saying that, this application deals with parcel A and this application deals with parcel B and this would deal with parcel C. Makes it easier, at least for me, it would be easier to go through the thing. Just a statement there. I don't know if the others have that problem too, but I do.
Through you, Mr. Chair, acknowledge. I appreciate the note. Staff have the same challenges internally on circulations.
Any other business by committee members?
Sir, if I may, I know you remember the principal. Over a half hour ago, you told my colleague that she could go get the map, and she said someone else could show the map, and you nodded at that. So I'm a little surprised that you're not allowing that right now. It'll take 5 minutes, but it's something I think that you told her she could do.
I will allow it.
Thank you.
Right, providing committee members are agreeable. Everybody agreeable? Okay,
Sure, why not?
fair enough.
What we have here is
Don't everybody speak at once, okay?
what we have here is a map that shows, for example, this entire area that is yellowish green. It's referring to land that's classified class 1, 2, or 3 land. There are roughly over 5,000 acres that are represented in that. And I just want to make a point that when you think about the zoning and the land use that we have in our province, can you hear me, by the way?
Yep.
When you think about the land use, we have the curiosity that in our township, there are only roughly 500 acres of land that are zoned as prime agricultural, and they're found in the Moscow area. Now, it's interesting that in that small square in Moscow, of that 500 acres, most of it is not actually even class 1 or 2. A lot of it is class 4. But in this whole area that's looking at north of Centerville, where we are, further east to Enterprise, we're talking about an over 5,000 acres that are class 1, 2, and 3 land. And mostly class 1. And yet, because of the way in which our zoning has gone in our township, they are rural and you're allowed to build on it. I just want to suggest that please keep that in mind, that there's something wrong with the way we are working in this township. And that's really, really all I want to say right now in this comment. And I thank you, Mr. Chairman, for letting us speak.
We'd like to know on what basis this area here is classified as a prime agricultural area, because only a Lear study can do that. But the Lear study will take into account, and you asked before, Ms. Fenwick, about, you understood that class.
We need a motion,
Part of the larger
because
area.
this is gonna fall
Well,
under
we
other
thought
business. We need a
large.
motion to let this be on the floor from one of these guys to move
We
it
thought
second
a
to say
very large area.
discussion related to
One
ag
Oak
lands
Street,
in the township.
1.2 slope
I can
down
jump
along the
and say
Napoli
that.
River Valley, north of Senator is a huge area. And that is designated as prime ag by the official policy statement, which overrides your official.
This whole discussion's being considered by council right now.
Thank you.
Yes, Bob?
Any lobbying for this group? Because there's a lot of severance have gone on this town here, at township lately. How come this is the only one you're picking up?
Well, that's where it started. We saw it. We saw it, and I mean, we can't handle all of those, but this is the one we noticed the wells being drilled on. When we're walking around the creek, you can see them from there. And so we were very surprised because it's a very productive farmland. And we know Mr. Galbraith.
But it's kind of not fair.
No, it's not, it's unfair to be on the field because they were first.
Yeah,
But
well,
really,
still,
the fact
still.
is that they did not have to consider any of the things that were being mentioned. They've been ethical in purchasing the land and wanting to develop the land because we only have rural. That means we don't pay attention to what's underneath the ground. Reach out, so we don't pay attention because we don't have bylaws. If you don't have a bylaw, it means you're putting the words in the official plan and not having a bylaw to enforce it. So when you look at it, they were first, they were on a prime farmland. Everybody saw the height of the corn. But the fact is, they did not have to consider that. They didn't have to consider this recharge. That's legal. They did not have to because it's rural, and we're all rural. And what we're concerned about, Bob, is what's coming. And it's not a myth. It's what's coming. We're seeing now that you have that much top quality farmland. And Ontario is a food importer. Taking the last 3 years, we're food importer.
Yes.
We are having to bring food in from elsewhere to handle our population growth in the GTA. You guys have this kind of land that produces food.
Okay, but how come you people never approach the federal government or the provincial government or?
Well, yes, we, yeah.
What they think?
Well, we've been putting our ducks on.
We thought it was ethical to first deal with our local government. And way back when this first happened, that we went, there was an open door, there was an open window of opportunity.
We can't
And
let
it's
this,
called.
we can't let this keep going too far.
Yeah.
This is-
Yeah.
We're still,
Was a guy named Keene who ran MMH and the latest, and there was an open window there for a while. And it didn't work out that we identified any more than what was the old ward. Basically, we surveyed the old ward, we didn't survey other areas because they never had any PA. They only had rural in Newburgh and in Sheffield.
And that whole PA zoning was based on, I think, municipal taxing,
Is that square areas?
Yeah.
Yeah,
So-
it wasn't based on solar classification.
It's time to really try to do what we can to protect the farmland, and you can't wait 2 to 5 years. Well, we know the rate at which they're going now, you know how fast.
Okay,
These changes are going on here. You have to come from the top down.
Yep.
They have already.
So,
And that, yes, absolutely. And so that's why, yes, everything we are producing.
nobody can hear any of this, nobody can hear
on.
any of this online. We gotta get the meeting.
You say, well, we concentrate on that, well, that's what started.
nobody can see this online, okay? So I need a motion here to accept their presentation so that we have it recorded in the minutes. Moved by Bob, seconded by Marilyn.
So-
Okay,
If I may, Chairman, so moved by Bob, seconded by Marilyn, that we accept the presentation by, for simplicity, may I say, Mr. Ellens, respecting agricultural lands in the community, in the township. Is that fair?
just so we can put this in our minutes. If Bob and Marilyn, the mover and the seconder, are okay with that, that'll be how we're classifying this in our minutes. So, thank you.
All those in favor? Carried. Okay. I need a motion to adjourn. Moved by Bob, seconded by Aaron. Thank you. Everyone have a good evening.